Item number 1.
So,
When my lord are not after application, he has to be. Only point is left out the two judgments you will
That-
cite, I will answer. I make also ready, but
Yeah,
unless
I
he
think-
formally cite.
those have been mentioned in the written notes of argument.
I mentioned that thereafter my lord 3 judgments cited. And I make myself ready to answer, but unless he formally lays before my lord, I should not. Their argument completed. Thereafter he take this point.
Those authorities have been mentioned in the written notes of argument.
Subsequent one he has been made. Subsequent detailed submission, which they have filed. So when we make the ready our submission, we will incorporate that.
Hmm.
But that was not, those judgment has not been.
I don't think that you
written
You
notes
don't
of
mind.
argument are written notes of argument are
না, বেশি সময় তো নেই।
No, written notes of argument.
Appellant written notes.
It a respondent. Appellant.
That is our, but here we will also not find the answer to those judgments.
Answer to those. Written notes.
রিটার্ন ফাইল করেছিস দেখি কোথায় আছে সেখান থেকে না না আমি তো ফাইল করি দেখে দেখ
আমার পাতলা বেশি মোটা
আমাদের ডিটেল নোটস অফ আর্গুমেন্ট
অত ভেতরে যাবে না উপরে থাকবে আলাদা করে আলাদা সেলাই করা
পাতলা
The written note only of the respondent. Like
আমাদের কি আছে ওর সাথেই আছে
বেশি খুশি রাখতে গেলে প্রবলেম
this one you have filed.
this one detail notes on
The newly added judgments
newly added there.
have been incorporated in the written notes of argument.
that's why you lordship pressed for today.
Then what to be done?
I feel embarrassed my lord. In these circumstances I cannot say anything. I should
No,
not make my submission merits.
Can it be no? Can it be listed on second?
Second, yes. Second will be 330. Justice Basu will be retiring. That those informations law I can say wrong. No problem about that. But this information my lord can take it sacrosanct. When will not work.
So
টি30 আছে তো
I think that
learned advocate representing the appellant
জানে
seeks an accommodation for this day on the ground of his learned senior. Mr. That was
বেশি খুশি প্রবলেম আছে
the matter appeared on 2nd of January 2026 at the
as today is Friday, that is also Friday.
may not be to maybe 10:30. That's why.
Okay. 10:30
না my lord is sitting with whom?
Friday, generally on Friday,
Friday to
generally on Fridays,
single bench.
single bench generally.
Keep it, I have no problem.
No problem. 10:30. At the top.
Get food. You have it? I say, yes, Mr. Ghosal is not well. Then he said, what do we do? Second, next matters. Item number 2.
Learned counsels,
Yes, sir.
while preparing the judgment and while going through the written notes of argument, in your written notes of argument, you have mentioned that you have not got you were not given the opportunity to submit in respect of the second substantial question of law. Is it fact?
No, it is not a fact.
In the written notes of argument, it is stated, it is mentioned there.
Please,
For
please.
that reason only.
No, minute. I
has been
strike down. It is. I can't say that. I was given all opportunity by your lordship, but I don't know how it came.
Oh, yeah. Paragraph 18. Paragraph 18.
Can you give me 1 minute, sir? At the time of the argument on behalf of the appellant, there was only one substantial question of law to be argued. Yes, that was the initial position, which was formulated on such and such date during the admission of the appeal. The mandate of section is so and so. Appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. The appellant, apart from drawing the attention of the Honorable Judge, finally hearing the second appeal to the plaintiff, written statement, the judgment other of the court below as noted. No, I didn't mean it. It is not that. Some formulation of sentence may be wrong. I have been given full opportunity. Lordship, kindly ignore it. I don't touch it after filing.
In respect of your written notes of argument, you have gone through the entire ocean, apart from the two, including the two substantial questions of law.
This matter is also kindly explicitly Mr. Calcutta says that
Okay, kindly don't take me happy. I
No,
mean
no.
it.
That's why it was beyond my.
No. Initially, there was one question, your lordship framed another question.
Thereafter, during the time of hearing.
That expression has been correctly arranged. Your lordship, kindly ignore it.
So I think it will be. So nothing more to be submitted.
Nothing more to be. Your lordship has given us the exhaustive opportunity. Exhaustive.
Thanks for that.
Exhaustive.
The learned counsel, the learned senior counsel representing the appellant submits that the appellant has been given sufficient opportunity as regards to submission in respect of both the substantial questions of law, and there is no further submission to be made in this regard. Full stop. ठीक है. One thing, you are not the advocate on record. Where is Mr. Haldar?
Went to the doctor's chamber. He's on his way. I have been told that he will reach by 2:30 or 2:40.
One thing, on 1/6/2006, the word proceeding was substituted by the word suit.
Lordship.
And this suit has been instituted during the month of April 2006. Means at that relevant point of time, the word proceeding was
It was not substituted. There are both the words, proceeding or suit. The proceeding was deleted because there can be any other proceeding for eviction. Proceeding is a much larger generic term. Later on, the legislature found the word proceeding to be superfluous, not required. So it was dropped. Any proceeding, be it before the income tax tribunal, be it with this honorable writ court, everything is proceeding. Suit is a specific term to be dealt with by civil court only. The proceeding was unnecessary here, so they have dropped the word proceeding. At 2-3 places, this amendment was inserted.
where a landlord, section 6, subsection 2,
Lordship.
where a landlord has acquired his interest in the premises by transfer, comma, no suit for the recovery of possession of the premises on the ground of requirement for building or rebuilding or addition or alteration or requirement for own occupation shall be instituted by the landlord before the expiration of a period of 1 year from the date of acquisition of such interest.
Correct.
Substituted by the West Bengal Premises Tenancy Act, West Bengal Premises Tenancy Amendment Act 2006 for proceeding. It has been substituted.
I've checked the earlier copy also. Both suit or proceeding. Proceeding is a generic term, and suit is specific for civil court. In fact, I have filed a copy of the amendment also. The earlier copy need to be seen, but I am sure I've seen it. Suit or proceeding it was. Proceeding has been removed.
That be.
Yes. They have given the term substituted, not substituted. It was changed. Suit was already there. Plus proceeding was there. Any proceeding or suit. For eviction of premise tenant, there cannot be any other. Yes, Miro.
Is it so?
Yes. I don't have the unfortunately earlier copy of the unamended copy, but it was I remember. It was all along suit or proceeding. It was unnecessary, superfluous. There can't be any other proceeding. Even if supposing only proceeding was there, it makes no change. Suit is a proceeding. But proceeding is not necessarily a suit.
Mr. Haldar has come.
পুরোটা কপি আছে আগেরটা এই amendment আগে
You require the Bear Act or what do you
the
require?
earlier act before amendment
Acha, 1956.
56 before before this amendment
1997, the earlier one.
it is 2006 amendment prior to that
Prior to-
what was the position
শুনুন। ছয়টি amendment হয়েছে, ঠিক আছে? 780 If 10 minutes of program.
but my submission is our
Initially, it was a proceeding. So far, my knowledge goes. Initially proceeding because
As
there
far
was no
as-
suit. Subsequently, it has been substituted by the word suit, and the word
As far
proceeding
as-
has been deleted.
As far as
it
my
makes no
knowledge
it
of-
makes no difference in law no difference in law proceeding is not a suit
Learned counsel, when your senior is submitting,
Ah.
please be kind enough.
a suit is a proceeding but all proceedings are not necessarily a suit that is the idea any proceeding before income tax tribunal before the green tribunal everything is proceeding but suit is for civil court only.
Whether issuance of,
It makes no
for
difference.
eviction.
It makes no difference.
whether issuance of notice for eviction
Hmm.
will come under the purview of proceeding.
No. Proceeding, yes. But it is specific. Proceeding suit. Proceeding definitely. Any before any forum, any
No, we are not. We
like
are
that.
We are confined to suits,
We are confined to suit.
civil suits, not writ.
Amendment দেখেছি আমি। Amendment এর আগেরটা না।
Bear Act only হবে।
Where actually?
I have another book of 2006. There is another difference. So far as the amendment is concerned.
Proceeding award suit and
No. We require that one, which is prior to 2006. 1997, WBPT Act 1997, prior to 2006. We require that one.
Proceeding.
And
Proceeding.
whether the issuance of notice
But my submission will be it makes no difference.
comes within the purview of proceeding or not. This is the,
Because the notice usually is concluded like this. Yeah, if you fail this, I may file any proceeding, civil or criminal like that.
learned counsels. This is the moot point.
Can I kindly keep it on second?
Let the matter come. Come up on second. On this point only.
Only. So if it, I will collect everything below. On second, I will produce everything. On second, I will produce. Lordship need not take the trouble. I will bring the copy. Idea call.
Learned counsels.
Difference.
It makes no difference.
It doesn't make any difference because the proceeding initially we are prior to this amendment 2006, the landlord is to make an application that is not called as a proceeding. Subsequently, the word proceeding has been substituted by the word
Suit.
suit.
It has been very specific.
Difference.
So both of you are ad idem as to that.
There is no, it makes no difference.
Proceeding and suit are same. There is no difference.
There is no
Now, for
difference.
this purpose, in the
So far-
context, there is no difference. In this context, there is no difference.
The embargo will also not apply. So
From
far as-
All cases, proceeding.
From this end, the question is whether the issuance of notice of eviction comes within the purview of proceeding. It won't come within the purview of suit. After 1/6/2006, it is the landlord cannot institute a suit. So, as regards to so he can issue a notice within 1 year.
That is
The present situation is that.
Let me check.
We'll have to check up learned counsel. We will have to check up. এটা ওই আগেরটা মানে আগেরটা বলতে লেটেস্ট পজিশন যেটা
Well, keep it on second. I will bring all the prepared amendment, after amendment. What is the effect?
Mr. Haldar, in your written notes of argument, including the two substantial questions of law, you have narrated the entire gamut of WBPT Act. Is that written notes of argument? Okay, so paragraph. From this end, a question has been placed before both the learned counsels as to whether the earlier, Act of 1997, prior to the amendment of 1/6/2006, that is, as regards to section 2, subsection 6 of the said Act, mentioned the word "no proceeding shall be instituted by the landlord." Section 2, section 6, subsection 2. Within inverted comma, section 6, subsection 2, where a landlord has acquired his interest in the premises by transfer, comma, no, within bracket suit, shall be instituted by the landlord before the expiration of a period of 1 year from the date of acquisition of such interest, and the note mentioned therein states that prior to 1/6/2006, instead of the word suit with a single inverted comma, instead of the word suit, the word suit with inverted comma, the word suit has been substituted for the word proceeding. ঠিক আছে, তাহলে সুটটা এবং প্রসিডিংটা সিঙ্গল ইনভার্টেড কমা ফুল স্টপ। The question now arises as to whether the issuance of notice for eviction by the landlord comes within the purview of the word proceeding or not, which was prevalent prior to the amendment of the 1997 Act on 1/6. Please be here. Let that old pre-amended statute come. Go through it.
I can recollect what is there, yes.
And apprise on 2nd of January as regards to this, only the word proceeding, whether the issuance of the notice comes within the purview or not.
But issuance of notice doesn't come with the purview of either suit or proceeding. Proceeding starts after the filing of the suit. Once it is registered with the number, then the proceeding starts. Back to that, it is nil.
Some
Field is virgin.
some authorities are required.
I will try to connect. Second.
That will clarify. Kindly be seated. Let the pre-amended version come. Pre-amended version tell na ওনাদের দিয়ে দেবে পরেরটা দাও শুধুমাত্র order C, which is section 6 subsection 2. Next.
Item number 3. Certified and is retired by the land, then said no land. You have to apply through advocate, then is applied. You don't know, land has to apply, that is also done. But they have not issued, showing some technicalities. I have not seen the report.
Go through the report.
Report na certified copy.
It is more summary submitted by the applicant has filed 4 copies of paper. You may depend on 21 November 1 copy of the paper has been served upon the respondent. Also in compliance with the this may be submitted to space to direct copy to provide statement. Number party paper book contains the the second section has sent the entire file to the Xerox section. Parties.
I don't know. I understand that you should have said that with the Honorable High Court has clarified. We should listen.
What is the problem now?
I don't know that technicality something applied in time on 28 November. Definitely given.
Problem is, my lord, from the paperwork it appears it is different from the certified copy. That's why your direction was there earlier.
Yes, there was direction.
To collect the certified copy of the that application is made by the friend.
What clarification is required now?
I don't know, Lord.
There was a direction given through the.
But they have not issued as yet.
Why not?
Asked by the clerk, then by the advocate, then advocate applied.
Office must have shown cause why they did not issue.
The Xerox section did not provide the photocopies of the said above documents to the parties. There must be some.
Direction, Lord should give the speech.
What direction? What direction required?
To be issued.
It has been directed.
Yes. There is extend the time.
There is no time frame given.
Or
Let
my
the
lord,
matter- let the
it
matter
hard
appear-
on the,
Let the matter appear in the list on 19th of December. That
April.
is today.
and my lord,
Today.
within that time, office could not, my lord, able to give certified copy.
There must be some problem.
কোনো
That problem can be eradicated
কেন
by passing-
যায়নি সেটা বলেনি?
by passing an order.
There
By
must be
passing an
direct
order.
communication settled the period of problem. The advocate went there, clerk went there, the parties went there, even
Hey.
direct went
The learned counsel,
overruling
the learned counsel representing, the same happened to you.
কারণ
My lord, at
Same
first,
happened to you.
application was
আরে
made
কি
with,
জিজ্ঞেস করছে আপনারা অ্যাপ্লিকেশন করেছেন কি?
yes, yes.
সেটা কি রিপোর্ট দিয়েছে?
My lord, no. My lord,
Why not provided? Why? What is the reason
কি দিয়ে?
not
At
providing?
first, they told that
on the part of our part,
my lord,
for respondent number 4, when we applied through our clerk, they stated that your clerk is not entitled to apply.
take
for that.
copy,
Achha, according to them, who is entitled?
advocate.
Then they called me, advocate on record. I went there and
my learned friend
there-
was told
and
that there is no Okalatnama filed by him.
But see,
but I have a order,
Kindly see the
order.
Office ought to have given a report.
So far my little knowledge
কোথায়
it has
কোথায় আছে?
ওই প্রথমেই আছে,
The number 2,
number
But
2.
so far my
Number two.
little knowledge, it is a very old matter. Subsequently change of advocate, so far the non-availability.
No, if- If,
No,
No, no, it is
most
no,
probably.
if the wakalatnama is not available to them
দেখি-
or not filed, then
No.
No.
There is order
Number-
also by the
there is order.
register of the learned register, my lord.
এই যে, এই,
There is second.
Second one.
ওই যে স্যার যেটা হাত রাখছেন, আঙুল যেটা রাখছেন।
এই তো, there is order.
Last time it is not properly done.
Oh, it is not Vokalanama.
and the
No.
Yes.
No.
learned counsel, we cannot pick and choose only one single sentence. We'll have to read the entire. The entirety has to be gone through.
The power has been filed.
Generally, certified copy, if clerk is applied, it is issued, madam. I don't know how they are getting this private.
These
Only-
things have to be
Only one.
dealt by the court.
And then the senior officer said they will issue it.
Only
when they are-
one.
Only one, others are correct.
They don't go to the technical team.
not properly.
No.
ঠিক আছে, আরে ওটা one না
For only one person.
That is the Vokalatnama can be noted down.
না,
No.
not that. Kindly see.
There
So
is
far my
No, the learned senior counsels have gone through.
valid, not
that is
properly.
not found, that is not genuine. সেটা তো বলছি।
Not
Only one seems to be
Okay, one
not
there is-
signed. In proper place. Eight days.
But this, so far my
The learned-
knowledge, it can be solved. Your lordship's lot of application has been made,
Uh.
discrepancies arises.
Hmm.
So lordship's direction are given to the registrar to supply the certified copy in the court below, in court, before the court, so that that can be supplied to all the parties. It will be easier.
Court below.
Not
How?
court below নয়, এখানে কোর্টের কাছে জমা দিবে। Separate certified copy available
Like-
before the court, available to all the rest parties. Other than that, all the rest, it is not difficult.
How
Why
it
the-
can be? Court will pay for copy.
Why the Xerox section is there? They are there to provide.
They provide the dispensaries arises, all the parties have made the
আরে
application.
আমাদের
They are
কিন্তু
not
different.
entitled
They are
to,
not-
but what the appellant
What the appellant have done.
fault.
As regards to the
Why
respondent,
appellant was not given?
as regards to the respondents, first of all, rectify what is the defect there. Learned counsels, first of all, rectify that one. And as regards to the appellants and others, as regards to the others, let me.
My lord,
My lord, if one name is defective, the other 7 respondents are correctly cited, signed in the Vokalatama, then why the Vokalatama will be abolished, will be nullified?
Learned counsel, at this stage, this court won't go into the fact as regards to the
There is,
Wakalatnama.
they are saying that no Bhokalatnama has been filed, but it is in the order of register that Bhokalatnama was filed.
My lord, they since the old.
They have to trace out the Bhokalatnama.
Filing number also is there.
Filing number is also there.
কোথায়?
এটা এখানে আছে।
আরে সে তো বলছে ফাইলিং নাম্বার দিয়েছে ভোগলার নাম্বারটা
না অফিস বলছে যে ওকালতনামাই নয়।
না ওখানে পাওয়া যাচ্ছে না, নট নয়।
ওইটা আগে হোক প্রমাণ। এটা অফিসকে
However, my lord,
That is between the department and respective respondents. The court is not concerned with that.
No. Court is to see, my lord. Otherwise, how can
of
it
the
be?
appellant to supply the papers.
expert.
Appellant should be given within a basic period. Otherwise, the office is to report. Why office has failed to do so?
That report has been provided. Then,
So the it is report.
A report has been placed. A report of the assistant registrar dated 18/12/2025 has been placed.
আমাদের
From it
তো আমার
reveals
টুকরি সই করেছে।
the Xerox section has not provided the photocopies of the document
সই করতে পারে না।
to the parties. Ultimately, and at the last stage, not initially, at the last stage, who has paid for the documents? The parties or the learned councils?
And he has supplied by the blended council, our.
Council then also clerk.
একজন বল।
Our clerk is
এটা দেখি
employed and the applicant has
এটা দিয়ে দেন না কপি অন এই তো মানে লেট ইট বি অন রেকর্ড। এটা একটাই করেছেন,
Who has,
দুটো কই, দুটো আরেকটা কই, But একটা
who has applied?
Clerk for the appellant as well as appellant in person.
in person.
ঠিক আছে।
And what they require now? What the section requires now?
The section is saying that since there is an advocate, the party cannot apply in person.
What is the no? To the parties, full stop, paragraph. The learned
রেখে দিলে পরে
advocate on record, the learned advocate on record on behalf of the appellant, advocate on record. No,
So the clerk apply.
আরে
no.
কি আছে?
Clerk.
বাড়ি থেকে করানো যায়নি।
Mrs. Chakraborty on behalf of the appellant or appellants.
Lordship, I have not filed Bhalatama.
Well,
I
appellant,
don't have the
appellant.
power.
Whose name to be recorded?
Mr. Dinda is advocate on record for appellant, but the
Acha,
the.
the
Or your lordship
Mr.
direction.
Bakshi, Mr. Bakshi, the learned senior counsel submits that both the parties, that is the appellants and the learned and the clerk of the learned counsel representing the appellant have filed requisitions, submitted requisitions seeking the documents.
Copy
Full stop.
The appellant should
Full
pay.
stop. Consider the submission of learned counsels on consent of all the learned counsels representing the appellants and the respondents. The
Certified
Xerox section, the department
and
the
appellant
department is directed to provide
issue the copy.
certified copies of the documents, relevant documents, to either the clerk of
Yes.
the learned counsel or
Advocate.
the parties concerned, whoever has applied for the same.
Zero certificate, department with zero
Sir,
certificate.
only one thing kindly see.
No, learned counsel. The court won't go through.
Mokaddama has been
that one.
filed.
Not
They-
going to, will not go.
Department
not
will
going
trace
to
out the same.
whether
It is
there is-
filed. There is order.
whether there is discrepancy as regards to signature or not.
My lord, we have filed the Mokaddama which is in the order sheet, but they are not. They are telling that it is not traced out. Let them trace out.
আরে সেটা তো আপনি লজমা কোর্টে গিয়ে মেনশন করে করতে পারেন, সেটা তো আলাদা জিনিস।
না 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 at this stage তো আর লজিমা করে যাবে না।
এট দিস স্টেজ আমার সার্টিফাইড কপি দরকার,
Let the
সার্টিফাইড করে
matter
মামলাটা হবে।
Let the matter appear on 9th of January.
ঠিক আছে
One of the theories, revenue will not suffer. Therefore, certified copy will be issued. We shall pay the.
Yes.
Court.
No, that
That
is
is
the
the direction, that is the direction in the earlier order.
হ্যাঁ পুরো
My lord, the only one line which should be added, my lord. It means the already application is made. That's because, my lord, in the before vacation, they are not entertaining the further application. Since the application is made, that number should be entered into the order. Otherwise, there will be complication in this.
No, that is.
No, they were
Yes,
showing
order
the
transaction.
applications.
আরে বাবা পূজার আগে ভ্যাকেশন আগে তো নেবে না আর অ্যাপ্লিকেশন, ভ্যাকেশন আগে কোনো অ্যাপ্লিকেশন নেবে না।
ওরা আছে তো, order এ আছে তো।
এটা করাই আছে
আর
অলরেডি।
সেইটা রেকর্ড করাতে বলেছি কোর্টে, কোর্টে অর্ডারে রেকর্ড করতে
ঠিক
বলেছি।
আছে ঠিক আছে যাবো। কেন নেবে না কেন?
নিচ্ছে না, ভ্যাকেশন আগে নিচ্ছে না।
আরে হয়ে গেছে তো অ্যাপ্লাই করা, আপনার অ্যাপ্লাই
Next.
অলরেডি অ্যাপ্লাই
Already fine.
আচ্ছা
অলরেডি অ্যাপ্লাই
যাবো।
এটা কেন আমাদের
কেউ দেখে।
ওনা গেট
এই করতে করতে সব কথা চলে এলো।
In 6 subsection 2 and 6 subsection 4, it was proceedings only. In 6.5, it was further proceeding. What I mean to submit, they have treated it equally, no difference. 6.5 is further proceedings. But they have treated it equally. It makes no difference in law.
Section 6, subsection 5 applies to
No, I mean that composition,
applies to the to make the
non-applicability of the new act. Yes. The question is suit or proceeding. They have treated it equally.
So let us
Let us have it on second.
on
Yes.
second of January. Under some of the authorities, governments in Calcutta,
whether the
that
any
proceeding through that matter.
whether
The issuance of notice comes within the purview of proceeding or not.
issuance of notice,
Comes within the purview of proceeding or not.
obviously proceeding,
On second.
obviously proceeding. Only the name has been changed.
item number 4 and 5.
My lord, for 4 and 5, I am paying for unconditional apology, my lord. The files have been misplaced, my lord. I have applied for the certified copy, my lord, but it is the proof, my lord. Last occasion, I have prayed that
Can 3 is in regard to?
my lord, it will be limitation or substitution, my lord. I am not
Can-
having
Can 4 limitation?
can for limitation.
Can 3 substitution?
Substitution. My lord, one thing, my lord, item number 4, SAT 205, that it has been amicably settled, my lord. And so I am pressing for only 206. Devashish Ghosh.
What to be done now?
My lord, Devashish Ghosh is to be kept alive, my lord, and
The learned counsel, the learned advocate representing the, for the appellate,
for the appellant.
representing the appellant submits that the file is missing. As such, they have prayed for certified copy of the same. Full stop. Paragraph in such circumstance, let the matter go out of the list.
Item number 6, I am for the appellant.
And for respondent number
Now, my lord, frankly speaking, I could not conclude it within this short span of time up to 3:30. And my lord, also, my lord, your lordship kindly pardon me to saying so, my lord, I can't burden my client for this my lord, argument. So, my lord, I pray before your lordship, my lord, I have a talk with Mr. Minam. I have also informed Mrs. Chakraborty, and kindly keep it after vacation so that I can complete the argument on a day. two contentions are there. One is this, that Abdul Karim has transferred his share to Abdul Karim, not only Abdul Karim, Jarina and Meher Approach.
Hmm.
All these three has transferred their share to my predecessors. So, I became the absolute owner of the.
And
But-
at the relevant point of time, only Hasina, the first daughter,
It is alleged that only Hasina was
was the major,
was
major.
major. It is their contention that Hasina was major. So the transfer of Abdul Karim, Meher and Jarina is not maintainable.
Hmm.
And their contention is also that Meher approach, Meher approach
Left India and
left
settled in
India for
Bangladesh
Bangladesh.
in
I'm-
the year
I'm-
1946.
1946 in Bangladesh. I am
She,
harping this word of Bangladesh.
Yes. What will be the difference if she settles in England?
No, I'm submitting why. 1946, there is no scene of Bangladesh. Bangladesh only came into light in 1971. They are talking about 1946 and says that 1946, before leaving India and going to Bangladesh, they
Whether in
transferred
bracket
it off.
East Pakistan has been mentioned.
Malad?
Mentioned. East
No,
Pakistan.
East Pakistan was also not there. 1947, Malad, the division was there.
প্লেনটা তো ড্রাফট হচ্ছে 2009 না?
সেটাই তো বলছি। In the plane was
So there was no chance of either Bangladesh or East Pakistan or whatever of that sort.
But their specific contention is this in the plaint. Specific amendments that before leaving for Bangladesh, the execution Heba was made. By Heba, the property was transferred. Kindly see the printer to copy লাগবে. The
Trial suit
LCR.
title suit TS. You are referring to which page of the plaint?
Page 3, paragraph 4 onwards.
Yes.
May I read for that after the death of Ahmed Hussain, he was the original owner. The suit property was recorded in the name of his wife, Ajijan Bewa, by virtue of a registered
পাঁচখানা সেট দিন, পাঁচখানা সেট পাঁচটা।
Bewa, that after the demise of Ajijan Bewa, her above named 3 daughters inherited the suit property, each having 1/5 share, and the son, namely the said Abdul Karim, predecessors of the plaintiffs, inherited 2/5 share therein. Be it mentioned here that when Ajijan Bewa died, she died in 1944, said Abdul Karim was then about 14 years, and her eldest daughter Hasina was the only adult married member in the family. And I am harping upon this word, was the only adult member in his family. That for obvious reason, the said Abdul Karim, predecessors of the plaintiff, then a minor, only about 14 years, was brought up by her eldest daughter in her family. That apart, the said Hasina Bibi, since after the demise of her mother, Ajijan Bewa, used to look after the said suit property for self and on behalf of other heirs of late Azijan Beba, including the said minor Abdul Karim, since deceased. That subsequently, the said Meher approach left India and settled at Bangladesh. Then East Pakistan, where she later died. The plaintiffs do not have other particulars about the years of the said Meher approach. That prior to leaving India permanently in the year 1946, said Meher approach by oral heba gifted her share in the suit property in favor of her two sisters, namely Hasina Bibi, predecessors of the defendant number 1, and defendant number 2, namely Zarina Bibi, and her only brother, namely late Abdul Karim, the predecessors of the plaintiff, who duly accepted the said gift. So, before leaving, she by oral heba, she
Gifted her share.
Now, that is in 1946. Now, if your lordship kindly see the previous paragraph 7, it is mentioned there that Hasina was the only eldest member, married member in the family.
So according to you, Meher could not have gifted the property.
My lord, if it is their contention that only Hasina was the eldest person, the adult person, so other three are not the adult. So if their transfer is not also their transfer is also not permissible. Maybe oral heba, it's not possible because she has also not attained puberty at that point of time. Another thing is this, this Meher approach was the fourth among.
That is the point going in the mind of this court, that is as regards to the age.
Yes, age.
Whether
attainment of puberty. Yes. Now, all these transfer are in accordance with Shariat law. There is no problem with regard to that. It is admitted. Whatever transfer that has been made according to Shariat law, so some part of the I am accepting the transfer in accordance with Shariat law, and when the transfer will be made, then I will be asking that no, you have not attained the majority, you have not attained 18 years of age.
That cannot be.
That cannot be. That cannot be. So if you want to accept, you have to accept as a whole. Now, my lord,
so this is the point.
This is the point. And my lord, according to me, my lord, Hasina, Jarina, thereafter Abdul Karim and Meher approach. Meher approach was the last of the four heirs of my lord, Azijan Beba. So if Meher approach transfer was the youngest. If Meher approach transfer, I accept Meher approach transfer because they have accepted the Meher approach transfer. Oral heba. So, my lord, I being the third one.
According to you, as they have accepted the transfer of the youngest, they shall have to accept the transactions of the elders.
Yes. 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 Now, my lord, with regard to this transfer, my lord, my transfer, what the property which has been transferred to me, that was, my lord, made by a registered deed. By a registered deed, not oral heba. Abdul Karim's transfer in 1946, 27 July 1946 is by a registered deed.
Whose transfer was to a registered deed?
The Abdul Karim, the son.
That is registered deed of gift.
Yes. Sale.
That you say.
Yes.
Hasina purchased by registered deed from Jarina, Abdul and Meher.
Yes.
On 27/7/1946.
My lord. My lord. So, my lord, according to me, if Meher is the youngest one, then my lord, all the others are also measured. The transfer which was made by others are also measured, because according to them, mere approach was measured because transfer was oral, by oral they have transferred. So the transfer in favor of Hasina by Jarina, Meher approach and Abdul Karim are also valid transfer, and that is made by a registered deed of gift. Now, my lord, this gift was, my lord, challenged. They have said that this is not the signature of Abdul Karim, and handwriting expert was, my lord, appointed. They did not. This Abdul Karim's signature has been disputed.
The sole son.
Sole son signature has been disputed, that this is not the signature of the Abdul Karim.
Handwriting expert was allowed.
Handwriting expert was allowed.
What was the opinion of the handwriting expert?
It says it differs. With which signature? Well, it said that it is admitted signature of Abdul Karim. The comparison was made with the deed and the admitted signature. Now,
which had been
what
signed
yes.
by Abdul
Now,
Karim.
now, Malad, I am asking you, what is admitted signature? Admitted not by one. Admission should be by both. Both of them admitted that this is my signature. This is my year's signature, my predecessor's signature. So, Malad, this was compared with the progress report, the signature that has been made in the progress report of the son of the Abdul Karim. That has been compared. So, Malad, no government document was, Malad, produced as an admitted signature. Wherever the signature of Abdul Karim was there in a government.
Whether you had agitated at that relevant point of time?
In suit we have agitated. In suit there is no scope to the other proceedings, because suit was there.
A handwriting expert was appointed.
My lord.
That has been appointed in the suit?
Yes.
They have opined?
Yes.
That the signatures are not telling?
Yes.
Thereafter, what your client has done, or what the appellants had done?
Well, the appellants argued that this is not the admitted signature. Admitted signature will be that signature which will be appearing in a government document issued by the government. Now, it's a private documents which was compared, and I am not admitting that this is the signature of Abdul Karim, which is appearing in the progress report of the son of the Abdul Karim.
Learned court had sent two signatures.
Both of
two
the
sets
progress
of signatures. Two sets of signatures.
68 as one of 1960 and one of 1969.
One set was admitted signature, and the other set, that is the signature for signatures which were under question.
Not admitted signature. When your lordship is asking admitted signature, I am admitting the signature which is appearing in the deed. I am not admitting the signature which is in the progress report, which has been compared. The signature of the deed has been compared with the signature of the progress report of the son, where the father has signed and returned it to the.
Did you raise that issue at that relevant point of time before the learned trial court?
Because that is the. That has been marked exhibit. So, it is very much issued. This argument was very much is there, because the documents were exhibited. This is this.
So from show.
The
signatures which you have admitted and which you have not admitted.
That is the exhibit,
exhibit document গুলো এখানে আছে হ্যাঁ কি টিন বক্স আছে টিন বক্স in the tin box.
Yes, maybe it's in box, because when it's a gift is there, deed is there, so it's বলতে পারছি না।
He will continue.
Abdul Karim has signed in English.
Yes.
This one is marked exhibit
E. Now, my lord, this signature is of 1946 and 1968. 68 and 69. Gap of 23 years.
1946. Whether it was executed on that day or during that year,
Beg your lordship, pardon, my lord.
whether it was executed during that year or prior to that.
In 1946, it was executed.
And an exhibit.
This is in
Progress report
progress report
of the
school
of his
of his
daughter.
son,
Of his, no, of his daughter.
daughter, I'm sorry, daughter. It is
You are
not the
telling.
it is not the signature of, my lord, any my lord, government document. He was working in dock labor board. Signature could have been compared with the signatures appearing in the any documents of the dock labor board where he was working. That has not been done. Bank account, that has also not been produced. It is this, my lord, certificate, the, my lord, progress report, which has been taken as an admitted document, which I am disputing.
So that's so. It was compared with the signature.
Yes, Lordship. But Lordship, whether in second appeal now they can take this point, there is concurrent finding of fact, Lordship, and no substantial question of
Yes,
law was
yes.
also
That
formulated on
document
that.
document is in question.
They did not.
1946 document is in question. So obviously I can.
Within the substantial questions of not substantial questions.
These are
When your
factual
lordship will
findings,
be
Lordship.
considering the 1946 document, that is with regard to the age that is coming, the documents, my lord, coming along with the age. So, my lord, definitely this is, my lord, and required documents to be placed before your lordship for your lordship's consideration. Yes. দিন এগুলো রেখে দিয়ে ওগুলো আবার হারিয়ে যাবে কোথায় তখন।
Because in the paper book সব ডকুমেন্ট গুলো থাকে না বলে এলসিআর গুলো আনা হয়। তাহলে তো সাবস্টেন্সিয়াল কোশ্চেন অফ ল ফর্মুলেট করার দরকার ছিল। These are concurrent findings of facts are there, Lordship. They also did not challenge the expert's report.
চাবিটা কোথায় এটা?
ওনাদের কাছে।
ও আচ্ছা।
ওরা চাবি দিয়ে দেবে, আপনি দিয়ে
আমার সালাম।
ও পরে আবার বলবে এটা।
আপনার ফিঙ্গারপ্রিন্ট পাওয়া গেল ডকুমেন্ট।
So, my lord, if this document subsists, this might transfer in my favor, subsist in two ways. That the signatures is not, my lord, not comparison is not proper, because, my lord, I am submitting this is in in two scores, Malad, that one is, this is the comparison with the school progress report. Secondly, this was this progress report was signed in 1968-69, and whereas the signature appearing in the deed is of 1946. So, Malad, with the age, Malad, the signatures differs. What I am signing today, Malad, after 5 years, I may not, my signature may not tally with the signatures. It's obvious it will not. Now, Malad, the second thing is, Malad, the transfer of Meher approach to the other three. I want to, Malad, submit before your lordship that Abdul Karim was major because Meher approach was, according to them, major. Who was the youngest member. So, Malad, if Meher approach transfer is, Malad, admitted, then the transfer of in favor of my predecessors is also admitted.
Had the capacity to transfer her share. So obviously these persons,
This person,
being elder to Meher Afroz,
and that too by registered. That too by registered documents. The Malad position was handed over to me. My name was mutated in the records. So, Malad, the three things which has to be, Malad, cleared, that the donor has, Malad, made a declaration with regard to the deed, the acceptance of the deed by the, Malad, donee, and, Malad, delivery of position. And delivery of position. Malad, these three things has been fulfilled by the transfer of 1946. Because, Malad, I am in, my name was recorded in the records. I was in position, and Malad, I have accepted the deed because by such deed I have recorded my name. So, Malad, the point which has been, Malad, raised, that whether I was 16 years, below 16 years or not, it is not, now it is not there because, Malad, the transfer of Meher approach, who was stated to be, Malad,
No, Lordship, nowhere stated that she was the youngest. I took Lordship instruction. She was
at
not
the time, you
youngest.
will get your chance.
No, because that is
you will
already
get-
also in the plane.
You will get your chance. Why you are so
Where
much
are you saying
agitated?
this?
Why you are so much agitated? You will get your chance. You take note and argue.
that is the reason why 5 sets of genealogy was prepared and handed over to each of you, each of the sets. Now the question is, all the respondents admit about this genealogy. Have you gone through? Is it not correct?
But for mine, defendant number 2 may not, I'm appealing for defendant number 2 may not.
Who are the successors of?
Of Aziz and Beba.
All are from Ahmed. All are from Ahmed Hussain.
The original.
Ahmed
Malad,
Hussain, Ahmed Hussain existed at the time of Babur.
Zarina will be Zarina.
Zarina, second one. Second, who was the second daughter?
Yes.
You are representing?
Lordship, Abdul Karim. According to us, we were the youngest son, not Afroz. Because, Lordship, in the plaint also, Lordship, nowhere it is mentioned that Afroz is the youngest son.
So there is controversy as regards to Abdul Karim and Meher Afroz.
Yes.
You are representing?
For the Karim also.
He's my advocate on record.
You are representing? Unknown.
Parvez Ahmed.
for which?
Check it.
Parvez Ahmed.
Yes.
Abdul, he's a near of Abdul Karim.
আমরা খালি বলছি এ আগে only yes I am lordship 2 to 5 I am 2 to 5 she's 1 yes we are all for Abdul Karim lordship she is appearing for only one of the heirs of Abdul Karim, that is Parvez Ahmed, the second person.
Do you have any instruction? Not aware.
Lordship, my instruction is that after Zarina, yes, after Zarina, Meher Afroz, and then Abdul Karim.
As regards to Hasina and Zarina, there is no
There is no dispute. No.
only the dispute is Meher and Abdul.
Yes.
Who had obtained the loans and who had obtained the steal.
Now, my lord, I shall also place before your lordship with regard to the genealogical table, my lord, the who is the youngest one, who is the younger one, my lord, that will be appearing, my lord, perhaps in my lord, in Exhibit C.
Exhibit C.
My lord, I shall on the next day I shall place it because my lord,
That Exhibit C is
Exhibit C is the my lord. If your lordship kindly come to my lord, page 26 of the paper.
in the trial court judgment. It will be
Yes.
Exhibit 3, the C.
Page 26, my lord. Running page 26.
26, yes. Exhibit
Exhibit C, last. Copy of notice issued by Bukoilas Estate of Central Bank of India on 28th May 1936 is marked as Exhibit C. Here from my lord,
what is that document?
the by which this Bukoilas Estate, my lord, the property was originally with the Bukoilas Estate, my lord, from whom my lord, I got the property.
Ahmed Hussain obtained the property
Yes, yes.
by way of purchase.
It was no, not by your purchase. তবে দেওয়া হয়েছিল আমাদের সঙ্গে কিভাবে পেয়েছি it was a tenanted property. It was a tenanted property. Tika tenancy property.
What will you take?
ওটা কি Exhibit C? দেখি এক মিনিট।
এটা আমাদের এখানে কোথায়?
Jarina. Rule approach. 6 to 9 are all minors.
Yes.
That is 6 to 9 are all.
The conclusion that from this document that whether
It is a notice. It is a notice, not that it is documents admitted. According to age, according to they have sent the notice.
In between Abdul Karim and Meher Afroz.
Yes, she is a predeceased daughter. As per, yes, Mohammedan law, she will not get any share.
So basically, these two are my argument. And
Attaining puberty is the
question. Gone through. With regard to the age of their predecessors, that is Abdul Karim, they are not sure what is the age of their father at that relevant point of time. Because in the cross-examination, she said, the plaintiff witness number 1 said, I have no knowledge whether the age of my father, as mentioned in several documents, were stated to those authorities by my father himself or not. So, the declaration that has been made, whether it is of his father, the documents which is appearing, which is the date, the age as has been mentioned, whether it is of their father or not, they are also not sure. No, it is they are saying that they are not sure about their father's age. In the plaintiff's witness cross-examination on 19th April 2007. PW 1.
Okay.
19th April 2007.
It's a DW1. It's a DW.
That if the Abdul Karim's transfer is valid, he attained the puberty, then his transfer is valid. So, my client will get the property, and that is the point, to be adjudicated by your lordship. Yes,
Therefore, it will be as regards to puberty.
my lord. And whether the transfer with whether the transfer, I am accepting the transfer as Shariat law. So, I have to accept as a whole the Shariat acts, not in piecemeal, that I will be accepting the transfer.
When we have accepted the oral gift, oral demo of mayor of course, they will have to accept the transaction made by the elders.
But the shares according to Muslim law are different.
But to that effect also, Chakraborty is denying as regards to who is the youngest of the lot.
Well, that is, Malad, that has to be borne out from the documents itself, Malad. There, so Malad,
Or we reading from the document.
yes, the Malad, the specific I have just now placed before your lordship the in cross-examination what they have made. Well, they said that they are not aware about the age of their father in what has been mentioned in different documents. And may I come on the next day with fresh mind?
Fish.
Advocate record will be sufficient.
No, Malad, Malad, my I know, Malad, he will be able to.
This is required.
He will be able to.
It is not as regards to capacity. Is the learned senior counsel required? Any further submission required?
Malad, some of the documents I shall go through and Malad, please be your question.
Has to be, all the chamber works have to be done during the vacation.
But my difficulty is this: all the documents that has been there is not with me.
Learned counsel on the respondent.
Lordship, we shall supply.
Provide.
Yes, yes, we shall supply.
That is Monday.
Within Monday, Lordship.
There won't be a direction to that effect.
Lordship.
Cannot be.
No.
Yes.
Representing the appellant submits at length but unable to conclude due to paucity of time. Full stop. Let the matter appear on 02.
Not
No,
second, not
not
second.
not second, Malad, on 9. Joint prayer from this bar to your lordship.
The learned counsels representing the appellants and the respondents, let the matter appear on 9th of January 2026.